designed for juveniles, so it's a very isolating experience. And so my role was more to keep him company, to not have him feel so isolated, to make sure that the needs he has, as every other individual who is housed at the Oakland County Jail has, and that they are being met. But his life is salvageable. His life is rehabilitatable. There was a book that I know was referenced during these proceedings, and I believe in the parents' proceeding as well. And it is written by Jillian Peterson and James Densley, both PhDs. And the book, the title is The Violence Project. And there was an interesting few sentences in there that struck me when I read it. They equated someone in crisis like a balloon full to bursting. When a balloon is inflated and stress or tension is applied, stretching the body over the air, the bigger the balloon gets, the more likely it is to pop. A fully inflated balloon becomes so fragile that it must be handled carefully or it will break. Prosecutor McDonald said, there was a lot of failures here. It doesn't diminish what he did, but there were a lot of failures that someone could have deflated that balloon a bit that could have potentially prevented this incident of occurring and us being here today facing the decision that you have to make. But to me, his life is worth salvaging. His life is worth rehabilitating. And as I know the court knows, all the lawyers in this room knows, that you have to fashion a sentence that is punishment, deterrence, protection, retribution, and rehabilitation. And if you look at him as a human being who is salvageable, who is rehabilitatable, then life in prison without parole is not the appropriate sentence. I have always been impacted by Brian Stevenson, who is the author of Just Mercy, A Story of Justice and Redemption, when he says, each of us is more than the worst thing that we have ever done. And I know everybody who spoke today probably cannot see that in Ethan, but his life is worth more than the worst thing he did. And what he did is probably the worst thing that anybody could do on the face of the earth. But I care about him. I know his team cares about him. And his life is worth not life in prison without parole, but is worth a term of years. And I ask you to sentence him to a term of years.
Thank you, Ms. McKelvey. Ms. Lofton?
Ms. Hoppe, go next.
Very briefly, Ms. Hoppe, because I know that you all, I don't want your arguments to overlap, and so I'll listen to arguments, but go ahead, Ms. Hoppe.
Good afternoon, Your Honor.
Good afternoon.
My purpose in speaking today is to address two specific issues. First is the issue of making bombs for Hitler. I first became aware of this book because of media reports. As recently as Your Honor's opinion has mentioned this book because it was Ethan's favorite book. This book is published by Scholastic Publications, which, as Your Honor probably knows, and many people in this room do know, Scholastic is an organization, a company that specifically provides books to schools. They provide them to students in schools through those little newsprint flyers that come home once a month, once every other month, for parents to buy books for their children. They run book fairs in schools. They provide opportunities for teachers to buy their books to have in the classrooms. This book is about 200 pages. I've read it twice now. The age group that this book is geared toward is 9 to 12 years old. This is not, despite the title, and that's kind of why I'm addressing this book. It's not a pro-Hitler, pro-Nazi book. It's not a how-to on how to make bombs or anything of that sort. What this is a book based on the real life stories of, in this particular case, a Ukrainian person who during World War II was kidnapped at the age of 9 and enslaved by the Nazis. These stories came to light after the fall of the Soviet Union in 1991. Ethan loves history. This book is about the 9-year-old main character who once was kidnapped, was thought of as a useless person because of her age by the Nazis who took her. She went on to arrive at the first work camp where she was enslaved, to be treated as, referred to, and called as subhuman solely because of her ethnicity, being Eastern European. It follows her as she worked in the very brutal slave labor camps, as first in the laundry, then because of her, and I use quotes for these, deft tiny hands, attention to detail, and patience, was moved to the metalworks building of that work camp. At the metalworks building of that camp, they prepared the bombs that the Nazis used. Her specific job was to load those metal bombs with gunpowder. She and the 5 other girls, because they were all maybe 15, 13, 11, 9 years old, came up with the idea of replacing the gunpowder with the dirt around their work facility in order to purposely sabotage the bombs of the Nazis, because they were anti-Nazis. They were hoping for the day when the Allies would free them, not only from Hitler, but from Stalin and his force or influence over the Ukrainian citizens. This is one book in a set of 3, each from a different perspective. This particular young lady had a younger sister whose life was very different. At the end, when the war was over, this book, as well as the second book, who's about a friend of hers from the camps, talk about going from camp to camp, looking to reunite families, and how they did that with messages. It also indicates that they weren't able to successfully return to their country of Ukraine or Russia, because under Russian law, at that point, Stalin considered them Nazis because they had worked in these enforced enslaved labor camps. It's actually a very captivating series, and even as an adult, I enjoyed it. And I'll disclose I have a major in history, so history is also close to my heart. I can definitely see why, as somebody who enjoys history, Ethan would have liked this book. And again, because the title is so misleading about the contents of the book, I thought that was important to bring to the court's attention. Secondly, and I'm not going to detail or go over again the testimony of Dr. Romanowski from the Miller hearing. But I do want to talk about our prison system very briefly. The goal of our prison system is punishment and rehabilitation. And we know that because there are cells with doors that lock, but there are also programs. There are education opportunities, employment skills programs, job training programs, counseling programs, and even programs geared toward re-entry into society. There is a parole system, which Dr. Romanowski talked about, and I want to fill in a couple of blanks there. If given a term of years, which I am asking the court to do, Ethan would be eligible at the minimum number of years for parole. There is a board that would review his eligibility. Part of what they look at is a worksheet that includes all of the crimes he's committed, all of the programming he's participated in, and the extent to which he participated. It takes into account tickets and discipline that he incurred, if any, in the system, his mental health, and they also calculate the statistical risk of reoffending. This is all brought down to a number which tells them what risk Ethan or any other defendant in the prison system has of reoffending, low, medium, or high. And that's part of the basis of the parole board's decision. The other part depends on input from the prosecutor's office, input from victims and victims' families, an interview with the defendant, him or herself. The decisions of the parole board at one time used to be appealable. If parole is denied, the inmate can no longer appeal that decision. If parole is granted, however, the prosecutor's office has the opportunity to appeal that decision. The parole board is a specific group of individuals with expertise in parole. If a defendant or if Ethan has not been rehabilitated, parole is denied. And as Dr. Romanowski testified, in a situation such as Ethan's, it would be denied for probably a period of 5 years. There could be a situation where, depending on Ethan's participation, that he may be eligible for parole within the lower numbers if he were given a term of years. It could also be a situation where, depending on the parole board, he would not until he hit the maximum period sentence under a term of years. Considering the period that is currently under law, 60 years, plus the 2 years he would have to do as a felon using a firearm in the commission of the felony, he could be in prison for 62 years under the term of years Your Honor has as an opportunity or an option to impose today. That would put him at around age 77. So even a term of years is a very, very lengthy sentence and may likely be a life sentence. But what it does do is give Ethan the opportunity to demonstrate to everyone that he can be rehabilitated, that he is redeemable, and that he can make amends and contribute in a positive way to society upon his release. I join the comments made by Ms. McKelvey, as well as I'm sure those that Ms. Lofton will make. The Ethan I met 2 years ago is not the Ethan that sits here today for sentencing. He has made remarkable progress in addressing his issues. That's not to say he doesn't have a ways to go, because he does. But that's to say he's demonstrated that he can change himself for the better. And for those reasons, I ask your honor to consider a term of years as opposed to life without parole.
Thank you, Ms. Lofton.
Your Honor, nothing that I discuss is meant to be an attempt to take away from the pain and loss that we just heard about. The pain is palpable, it is real, and I don't mean to invalidate that with my comments. But as Ethan's defense attorney, my job is to tell this court what I know about Ethan and what I believe the sentence should be. We submitted a lengthy sentencing memorandum, and I know the court takes time to review all that, so I'm not going to repeat everything. But due to the gravity of this decision that the court will make, I want to highlight a few things. I would first like the court to know that Ethan is supported today by his aunt, who came in from out of state. Also, a number of juvenile lifers were here this morning, but had to return back to work. I know that the court reviewed the letters that we submitted, and we ask that you continue to consider those prior to sentencing. I first met Ethan on December 4th of 2021. That day, I met a broken and extremely sad and hopeless kid. He didn't look up. He didn't make eye contact. He barely spoke. In the first few months, I wasn't sure that we would actually make it to sentencing. He was depressed and still suffering from the mental illness that he came in with. After being arrested, he never saw the news or social media or the vigils that were held. He committed these acts and then was locked in a vacuum. When we had the initial placement hearing, it was the first time that he experienced the anger of his community and the pain that he caused. He did not take that lightly. Over the last 2 years, I have watched him go through all of the stages of grief. Ethan has never bragged about what he did. Ethan dreaded in court hearings because, unlike what has been said about him and what he wrote in that journal, he doesn't like attention. After being on medication and seeing a psychiatrist for 2 years, after having upwards of 175 visits with me, visits from Ms. Hopp and Ms. McKelvey, after talking to his aunt weekly, reading the Bible, reading novels, and spending so much time in solitary confinement, he is a different person. He has already made so many changes, and he is remorseful. He has been able to keep out the dark voices and thoughts. He sees the wrongs in his thinking and his actions. He has hope for the first time. He tries to be better every single day, and I am confident that he will continue to do that in the Michigan Department of Corrections, whatever your Honor's sentence may be. At the Miller hearing, the prosecutor introduced internet searches that Ethan made concerning punishment in Michigan. They also showed parts of his journal where he talks about a life in prison. Just because Ethan looked up what a life sentence is or what the punishment is for killing people does not mean that is the appropriate sentence under the law and under the facts that we are operating with. Would a healthy 15-year-old be okay with going to jail and prison for the rest of their life? Absolutely not. The fact that he even researched what his sentence could be and then still went forward with his actions only further shows how depressed and mentally ill he truly was. I want to talk a little bit about the journal. When you read Ethan's journal and you compare it to the notes from Dr. Anaker that we attached in our sentencing memorandum or the report of Dr. King, it sounds like a completely different person. And after meeting with Ethan for over 2 years, I now understand that the journal was the worst of the worst. It was an exaggeration of his thoughts. It was a place where he could say anything and there was no judgment. It was a sounding board without reverberation. He could make himself sound scary. He could make himself out to be a person that would be remembered. How do we know this to be true? We can look at the internet searches leading up to November 30th. We can also look at the step-by-step description of what was going on in his head that he gave Dr. Anaker. A few examples of the searches within a week or two of November 30th. Should you do something that scares you? What happens if you have depression and anxiety? What causes mental illness? Can you get in trouble for not doing homework? Am I a sociopath? Can hormones make you have bad thoughts? How to tell your doctor that you have depression? Can a therapist tell your parents? How to tell your parents you have depression? He was still trying to figure out what was going on with him. He acknowledged that something wasn't right, but he did not have the support or the connections with adults that could help him. So while just reading the journal and listening to his video the night before could leave you with the impression that this was a master plan that had been crafted for weeks without hesitation, I don't think the other evidence supports that. He struggled with his actions until the moment he came out of that bathroom. I want to touch briefly on the guidepost report, and I have never said that that report diminishes Ethan's culpability. Ethan pled guilty, not even no contest, and wanted to move directly to sentencing. Dr. Colin King in his detailed report and while testifying discussed implicit bias as a reason the school acted in such a manner when dealing with Ethan. He came to this conclusion because nothing made sense about Ethan being sent back to class. We obviously, at that time, at the time of the Miller hearing, we were not privy to the inner workings of the district. But the guidepost evaluation and report goes so much deeper than the rationale of implicit bias. The report says the school failed Ethan. The report found that the school should have conducted both a threat assessment and a suicide intervention assessment in light of Ethan's conduct, and he should not have been sent back to class. The report says they had a student with recent mental health concerns raised by a teacher who previously had mostly flown under the radar at a big school with poor grades, fair attendance, and no serious discipline history. A student who now on back-to-back occasions violates school policy. First, by viewing bullets, and then by watching a video of a guy gunning people down. That raises a serious red flag. It's not a close call. Ethan's concerning behaviors and statements at the very least might suggest physical violence or a threatening situation. So why is this relevant in this case and at this stage? Again, this report is not offered as an excuse or justification. This report is not offered to minimize the gravity, but we argue that this report, combined with the other things that we have mentioned, should persuade this court to a sentence of a term of years. If the professionals didn't recognize that he was on the precipice of a crisis, how do we then expect a mentally ill 15-year-old kid to be able to recognize that he was spiraling and come right out and ask for help? How can we expect a 15-year-old boy to tell a counselor that he had no relationship with his deepest, darkest secrets, the thoughts that took over his mind? Finally, I want to discuss rehabilitation. Montgomery versus Louisiana. While a sentencing court might encounter the rare juvenile offender who exhibits such irretrievable depravity that rehabilitation is impossible and life without the possibility of parole is justified, this penalty will be uncommon because of children's diminished culpability and heightened capacity for change. When there is no evidence that the defendant could not be rehabilitated, there is no reason to conclude that the defendant, like the great majority of youths, lacks the capacity to change and mature. People versus Taylor. No one has a crystal ball. And while it's impossible to say that Ethan will be able to be rehabilitated and be a productive member of society worthy of release, it will not be impossible to make that determination with decades of daily records of his behavior and human interaction. The parole board can evaluate everything that you do not have at this point to determine if he is rehabilitated. If you give Ethan a term of years, he will have to prove himself every single day. In my sentencing memorandum, I attached triumph reports from Sado that highlighted a number of juvenile lifers that were released under Miller. I also attached a number of letters from those same individuals who are supporting Ethan. In each of those cases, 20 to 30 years ago, a judge told them that they couldn't change, that they were irreparably corrupt, and they were wrong. Many of those individuals had no idea that the law would ever change or that they would get another chance to be released into society. Even knowing that, they did good things in prison. They took classes. They stayed out of trouble. They became better people. And when the laws changed and the court found that they could be released, they became productive members of society. Rehabilitation is possible, and those people are living proof. We are looking at the ability to be rehabilitated. We need not actually prove that complete rehabilitation has happened. He has participated each week in therapy and is on medication by his own choice. He has taken those initial steps to change. Ethan Crumbley is not the rare juvenile offender who exhibits such irretrievable depravity that rehabilitation is impossible and life without parole is justified. Your Honor, we ask that you sentence Ethan Crumbley to a term of years. Thank you very much.
Thank you, Ms. Lofton. With that, Mr. Crumbley, is there anything you would like to state before I pass sentence?
Your Honor, may he stand?
Yes, you may. Thank you. You may proceed.
I'd like to thank you for letting me speak, Your Honor. You're all here because of me today, what I did. My actions were because of what I chose to do. I could not stop myself, but I am the one who led to why we are here today. I do not diminish any ability to anyone who could have stopped me, of anyone of a school or parents. They did not know, and I did not tell them what I planned to do, so they are not at fault for what I've done. I am a really bad person. I have done terrible things that no one should ever do. I have lied, been not trustworthy. I've hurt many people, and that's what I've done, and I'm not denying it, but that's not who I plan on to be. Whatever sentence it is, I do plan to be better than I am. I don't know if you believe that, but records of 15, 20, 25 years can show that I will change. Because it may not show it now with only 2 years of records, but I am trying. And all I want is for the people I hurt to just have a final sense of culpability that justice has somewhat been served in any capacity that they can recognize it with. Any sentence that they ask for, I ask that you do impose it on me, because I want them to be happy and I want them to feel secure and safe, and I do not want them to worry another day. So I really am sorry for what I've done, for what I've taken to them. I cannot give it back, but I can try my best in the future to help other people, and that is what I will do. So thank you.
Thank you. With that, this court has listened to extensive evidence in this case. I heard 4 days of testimony from the Miller hearing. I presided over numerous placements hearings. I conducted the initial placement hearing in this case. And so the court is fully aware of the defendant's upbringing. I'm fully aware of the circumstances that brought him before the court. First, to the victims of the deceased, the court sends out its sincerest condolences to their family, to the injured victims, and to those victims as it relates to count 1, terrorism causing death. Thank you for your courage and strength in speaking today, as well as sending written correspondence. as counsel has pointed out, the court has read everything that you've submitted. I've read the defendant's sentencing memorandum. I've read the people's response thereto. I've read all of the exhibits that were attached, and I've read every single victim impact statement over the course of 3 days. Probably took me closer to 36 hours to read all of this. And so I've read everything and have gone back through the complete file. The letters truly gave the court a sliver of insight into the unique and amazing personalities of Justin, Hannah, Tate, and Madison. The court cannot begin to imagine the fear that the parents of those students at Oxford High School had on November 30th, 2021. I cannot even begin to fathom. To have to wait and mire to see if your loved one will return is heart-wrenching. And that's true terror. And not to have your loved one show up at Mire, the court could not imagine the pain. I know that whatever sentence the court imposes will not bring your loved one back or cure the mental anguish or lifelong physical scars that some of you have. But I hope that this sentence does allow you to close one chapter in your life. I also want to thank law enforcement that responded that day, because I know this has not been easy on them as well. As previously stated, the court has read defendant's sentencing memorandum and the people's response. Again, defense argues that defendant should receive a term of years because of defendant's alleged mental illness. Defendants cite People versus Bennett 335 Mish at 409, a 2021 case. The court notes that it is not saying because the defendant may be mentally ill that automatically means he's irreparably corrupt. What the court notes is that he has an obsession with violence, that this act involved extensive planning, extensive research, and he executed on every last one of the things that he planned. As the court stated in its written opinion and order regarding the Miller hearing, defendant's alleged mental illness did not interfere with his ability to extensively plan for months. His actions, nor did it interfere with his ability to execute those plans. This started with him asking for a better gun to conduct the school shooting. He had initially a .22 caliber weapon that he wrote would not do enough damage. And so weeks and weeks prior to this offense, he started to formulate this plan and knew and asked for the weapon that he could cause the most harm with. As counsel is aware, the goals of sentencing do not only involve rehabilitation, but also involve deterrence and punishment. Deterrence is two parts. It's private deterrence for the defendant in hopes that they would never commit an act like this again. But then there's also public deterrence, where the public sees the punishment that the individual has received in hopes that the public will never do anything like this in the future. The court has read the report from Guidepost Solutions. It was very lengthy. Respectfully, the court does not find this report to be mitigating in this case. The report simply points the finger at Oxford Public Schools. While the court agrees that more possibly could have been done, that issue is not properly before this court. We are here for sentencing based upon the defendant's actions, not the alleged shortcomings of others. As the defendant pointed out himself, he took responsibility, and he himself is not asking this court for a term of years. The court cannot underscore defendant's extensive planning and execution in this case enough. He practiced shooting at a gun range. He practiced racking and unracking the gun. And on November 30th, 2021, he could have chosen not to conduct the school shooting. When his parents were called to the school on that morning for his drawings, he could have said something then. He had a gun in his backpack at that time. When the school counselor advised the parents to please get him help within the next 48 hours, he could have stopped then and simply accepted the help that was going to be offered for him. Because according to the reports, his mother said that she'd get him the help. He could have changed his mind. Unfortunately, after shooting the first person, Phoebe Arthur, he He could have changed his mind at that point, but he didn't. He continued to walk through the school, picking and choosing who was going to die. As the defendant said in his own words, this is nobody's fault but his own. He stated this afternoon that with help, that probably would not have stopped him. That is absolutely concerning to this court. The court apologized to the victim for the bluntness, but defendant shot and killed Justin Schilling at point blank range after having him get down on his knees in front of another student. He shot Hannah, who was already shot once before. He walked up to her to finish the job by shooting her again. That is an execution. That is torture. He shot most people multiple times. And as he wrote, he did this for notoriety. And he wanted to go down in history as the biggest school shooter in Michigan history. The court cannot ignore the deep trauma defendant caused to the state of Michigan, but in particular, the Oxford community. The court simply cannot ignore that. The court notes that teachers and students returned to Oxford High School after this tragic event. The court cannot even fathom or imagine walking through the halls of that school knowing that your fellow student, your friend, your classmate was killed in a restroom or in the hallway. Most, if not all of the letters that I read advised the court that there are a significant number of people in Oxford that now have PTSD, that now have survivor's guilt, and deep depression that arose from this incident. Defendant's actions clearly created a new normal for all of the individuals involved, and all of those indirectly impacted as well. Unfortunately, this is what the defendant wanted, as he wrote in his journal. He wanted to see the impact of his crime, which is why he did not take his own life. Again, this goes back to the defendant's extensive planning. He chose not to die on that day because he wanted the notoriety. The terror that he caused in the state of Michigan and in Oxford is a true act of terrorism. Respectfully, defendant is the rare juvenile before this court. The court, having read the PSI and being fully familiar, but before I get that, I will also note that counsel brought up an issue of making bombs for Hitler. The court, that does not change the court's opinion about the defendant's obsession with violence. I thank Ms. Hopp for bringing that to my attention, but it still does not change the court's opinion about him being obsessed with violence, because his obsession was also outlined in the websites that he visited. His obsession was also outlined in his extensive drawings of violence. And his obsession continued, as I noted in the court's opinion in order, even while he was in the Oakland County Jail. With that, the court, having read the PSI and being fully familiar with the defendant and the underlying facts of this case, believes that it is in the best interest of justice as well as proportionate to the needs of this case to sentence defendant as follows. As it relates to docket 2022-279-506 FC, count 1, terrorism causing death. Sentences of the court is that defendant shall serve life without the possibility of parole, credit for 8 days served. Counts 2 through 5, homicide, first degree, premeditated murder, juvenile defendant. Sentence of the court is that defendant shall serve the rest of his life without the possibility of parole with the Michigan Department of Corrections, credit for 8 days served. On counts 6 through 12, assault with intent to murder. On each of the counts, defendant is sentenced to 18 years and 9 months to 80 years with the Michigan Department of Corrections, credit for 8 days served. On counts 13 through 24, those being felony firearm, defendant is sentenced to 2 years with the Michigan Department of Corrections on each of those counts with credit for 730 days served. Counts 1 through 12 are concurrent to each other, and counts 13 through 24 are concurrent to each other. Count 1 is consecutive to count 13. Count 2 is consecutive to count 14. Count 3 is consecutive to count 15. Count 4 is consecutive to count 16. Count 5 is consecutive to count 17. Count 6 is consecutive to count 18. Count 7 is consecutive to count 19. Count 8 is consecutive to count 20. Count 9 is consecutive to count 21. Count 10 is consecutive to count 22. Count 11 is consecutive to 23. And count 12 is consecutive to count 24. All of those consecutive counts are by reason of the felony firearm statute. Is there a challenge to restitution here?
There is not, Your Honor.
Thank you. Restitution will be set in the amount of $20,781. State costs will be set in the amount of $1,632. You are not to have any contact with Oxford High School or enter Oxford High School. You're not to have any contact whatsoever with the families of Madison Baldwin, Tate Meyer, Hannah St. Juliana, and Justin Schilling. Also, you are not to have any contact with the following victims or their families, that being Phoebe Arthur, John Osito, Molly Darnell, Riley France, Elijah Mueller, Kylie Osage, Aiden Watson, and Keegan Gregory. And I will note that restitution is payable to the Crime Victims' Right Compensation Program. With that, Michigan Department of Corrections, did I miss anything?
Your Honor, I ask the court to order 130 crime victims fee, $60 DNA cost and DNA testing.
Thank you. DNA cost is $60, Crime Victims' Right fee at $130. Did I miss anything else?
DNA testing, Your Honor.
DNA testing is hereby ordered. Thank you. With that, Mr. Crumbley, you are entitled to file an application for leave to appeal. If you are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal. The request for a lawyer must be filed within 42 days after sentencing. Your attorney is going to be handing you an appellate rights form, sir. Do you acknowledge receipt of the appellate rights form?
Your Honor, I have tendered that to my client. He has signed it and I will tender it to the court.
Thank you very much. With that, counsel, anything else for the record? Not from people. Thank you.
Nothing from defense. Thank you very much, Your Honor.
Thank you very much. With that, deputies, you may take Mr. Crumbley. To those in the gallery, please be seated until he is exited.
Yeah.
With that, thank you all. The court will stand in recess.
All rise.
Recording stopped.